Thank you, and welcome to the webinar, the Arizona State Update, presented by Elder Counsel. I'm Brent Gunderson. Happy to be with you here today. Just a little bit about me. I'm relatively new to Elder Counsel, but have been with Wealth Counsel for several years. I've been doing estate planning now for a little over 28 years, and much of that has involved elder law, but fairly new to Elder Counsel and to some of the planning that Elder Counsel allows us to do. So that's a little bit about me. Been doing this generally for a long time, but new to this particular area, and excited about being a part of Elder Counsel. So today we'll do an introduction, talk a little bit about Arizona Medicaid. It's a little bit different here. We don't even call it Medicaid in Arizona. We'll talk about that. We'll take a look at the numbers, the income and asset eligibility rules, transfer penalty numbers. We'll look at calculating the share of costs here in Arizona, and then some strategies to assist clients in qualifying for benefits and understanding the process of getting care here in Arizona. So here in Arizona, the Medicaid agency is known as the Arizona Healthcare Cost Containment System. We refer to that as ACCESS. And pronounce it ACCESS. The long-term care is provided through the Arizona Long-Term Care System, commonly referred to as ALTCS, A-L-T-C-S. So ACCESS and ALTCS are the two programs that you'll hear referred to in Arizona, as opposed to Medicaid. So ALTCS covers long-term care and medical expenses, including those listed here on the screen. So it covers custodial care in group homes, assisted living and memory care facilities, covers skilled nursing. It can cover in-home caregivers, including family members, medical and non-medical. It can provide attendant care, adult day care, behavioral health services, rehabilitation, can allow for home modifications, non-emergency transport services, up to 600 hours a year of respite care. There's and other therapies, occupational, physical, and speech therapies. So the eligibility cutoffs for ALTCS coverage here in Arizona, in 2016, the income limits are the same as they were in 2015. For an individual, that's $2,199 a month. And this is 300% of the predetermined federal benefit rate. The 2016 ALTCS income limit for a married applicant is determined in one of two ways. It's either the $2,199 a month if the income is the applicant's income alone, and that's determined by the name on the check rule, or it's $4,398 for both spouses if the income's combined. So the following sources of income are counted as income for purposes of determining ALTCS eligibility. You see the list there: alimony and spousal maintenance count, annuity payments count, child support is included, disability insurance payments, gifts and contributions are considered as income. Inheritances, rental income, Social Security benefits are counted, as is VA compensation, as opposed to VA aid and attendance benefits. Those are not counted. So the following are not considered income in determining ACCESS or ALTCS eligibility. The money from a sale of a resource, so if you already had a resource and you converted that to cash, that is not considered income. Money that a person receives to cover someone else's expenses and then uses the money for those expenses. So money just coming through in a conduit situation where somebody is giving it to an applicant use for somebody else's benefit, that would not be considered income. Replacement income of something that's already been counted would not be counted twice or again. A return of incorrect payments. Now we'll talk later about some cures, which they're pretty strict on here in Arizona. But if there were valid and innocent incorrect payments made to an applicant, returning those in good faith would not be considered income. And vendor payments, payments for customers' expenses made directly by a vendor to a third party. The following sources of income are also excluded for all tax eligibility, in addition to access. So interest and dividends are not counted in applying for long-term care through all tax. Reimbursements for job-related expenses, aid and attendance are not counted, and German reparation payments are not counted. Now, if there is a community spouse, the income, again, and the income is determined by the name on the check rule, the income of a community spouse is not considered in determining eligibility. However, if most of the couple's income is in the name of the institutionalized spouse, and the community spouse's income is not enough to live on, the community spouse is entitled to some of the institutionalized spouse's income. So the institutionalized spouse can get a deduction for part of their, and be able to basically allocate part of their income to that of the community spouse whose income is lower. So the minimum monthly maintenance needs allowance will range somewhere between $1,967 and $2,981, and that's calculated independently for each community spouse based on the cost of living. And we don't really have clear guidelines on how that number is created. Alltech's office calculates that and provides that, but it's in that range, and it depends on the cost of living and actual costs of the couple involved, and so it's going to be somewhere in that range, and that's really something that you end up finding out at the time of application as to what the minimum monthly needs allowance will be in each person's situation. If the community spouse's income is less than that monthly maintenance needs allowance, and the shortfall is made up from the institutionalized spouse's income. So if the community spouse has income greater than that allowance amount, then there is no deduction in this case. But if it's lower than that amount, then the institutionalized spouse's income can be used to help support the community spouse. Now, if the applicant receives income greater than that $2,199, Alltech does allow them to establish an income-only trust, also known as a Miller Trust. So if the income is slightly higher than that and they would otherwise be disqualified, we'll talk more about these Miller Trusts, but you can create the Miller Trust, have the excess income go into that trust so that it is not counted to disqualify the person from receiving services. Now, of course, at the end of the applicant's lifetime, the assets in that Miller Trust go to reimburse the government, go to Access or Alltech, as the case may be, and that excess amount is also included in calculating the share of cost amounts. But someone who's slightly over the income amount, the use of the Miller Trust is a helpful tool to be able to allow them to still qualify for benefits and just shelter the excess amount or shelter. We put it into the Miller Trust where it can be used for the applicant, and then anything that's left over goes to the government later. So assets and resources. For a single applicant, they can't have resources in excess of $2,000. For dual married applicants, the $3,000 asset rule is in place. So that is pretty standard. Excludable resources, resources that we don't have to count in determining, in getting to that $2,000 or $3,000 limit. One vehicle, as long as the vehicle is used for the transportation of the applicant or a member of the applicant's household. So we can exclude one vehicle if it's being used. The primary residence, but only up to $552,000 in equity, and then only if the applicant or spouse lives in the home or lived in the home, but is absent due to institutionalization, but intends to return to the home. Or in some cases, if the home property produces income, regardless of the value of the home, the rate of return or current use. And those income limits can be a little complicated. We'll discuss those a little bit later in the presentation here. Other excludable resources in determining whether the person is below the $2,000 or $3,000 limit. Household goods and personal effects are not counted. A burial plot is not counted. Burial funds, as long as those funds are irrevocable. So if the applicant can get a refund or can get those funds back, then they are counted. But if burial funds are irrevocable to be used for burial, then those are not counted. Animals are not counted. A certain special treatment trust, an example, the income-only trust or the Miller trusts, the money in that is not included. Certain trusts for individuals under the age of 65 with a disability are not included, and pooled trusts are not included. Life insurance, as long as the cash value of the life insurance is less than $1,500. Now, annuities that are revocable are considered countable resources, and the value of the annuity is the cash surrender value. Now, if the annuity is irrevocable and not treated as an available resource, it still may be considered a non-compensated transfer and could end up resulting in a penalty period, depending on the circumstances under which the annuity was purchased. And we'll talk a little bit more about annuities later. But Medicaid-compliant annuities, if they are compliant, especially in a husband and wife situation, can be a resource that works well. But if it's revocable, they are counted at the cash value amount. Bonds are counted as a resource unless they cannot be sold for some reason. That would be pretty rare. Cash is countable except for coin collections if they can legitimately be treated as a personal effect, and collections oftentimes can be. Now, entrance fees to a continuing care retirement community or a life care community contract, those are countable if the entrance fee can be used to pay for care, and there's an eligibility for a refund upon death or upon leaving the community, and the fee does not purchase an ownership interest in the community. So it is countable under those circumstances, and a lot of contracts are set up that way, where there is a refund upon leaving the community or upon death, and the amount can be used for care, and so it's not really an ownership interest. It's and so those would be counted as a resource. Financial accounts are accounted as a resource for each individual listed on the account. So, joint accounts, if your name's on the account, again, it's the name on the check rule, it's the name on the account rule. If an applicant's name is on an account, then it's going to be counted as a resource. Including 529 accounts counted for the owner, and that's the person who contributed the money, but not for the beneficiary of the account necessarily. So if an applicant is named as a beneficiary beneficiary of a 529 plan but did not contribute the money and is not an owner, then it's not counted. But if the applicant created the 529 plan for their child or grandchildren and they're an owner, then it is counted, even though they may not consider it their money. And oftentimes when these 529 plans are set up, the donor, the person who contributes the money, considers the money gone. They consider it in the name of the beneficiary, but that's not the case. If they still remain on there as the owner, that 529 plan is counted. So that's an important thing to remember, that is a little counterintuitive and a surprise to many applicants. Home property is countable only if it's owned in the name of a revocable trust. And so if it's in the name of the, so this is one situation where, if somebody is, if they're going to be applying for Altex or for access, this is a situation where we wouldn't want to put the home in the name of the trust, because it makes an otherwise non-countable asset a countable asset. And so that's as far as funding in the estate planning, this is an area where the elder law considerations will override what we would normally be doing with revocable trusts. Life insurance, the equity value of a life insurance policy is counted as a resource to the extent that the cash value exceeds $1,500. So if the equity value of a life insurance policy is $1,500 or less, it's excluded. If it's $1,500, if it's greater than $1,500, then it is counted as a resource. Mutual fund shares are countable. Promissory notes, loans, property agreements are all countable. Sometimes there's an issue in determining what that value is. Generally, the principal balance is what will be counted. The applicant can sometimes provide a current market value that may be different from that, depending on circumstances. But as a general rule, it's the outstanding principal balance on any note would be counted. Real property is countable. There may be certain situations where where real property can be excluded if there's a good faith effort being made to sell the property. We've talked about if it's qualified under the home exemption, then it would not be counted. If the property is essential for the self-support of the applicant, there are circumstances in which it would not be counted, but just the income that comes from it would be. If property is on Indian tribal land, it's not counted. And there can be certain circumstances where there may be an undue hardship to a co-owner of the property. And in those situations, it's possible to have real property not counted as a resource for an applicant. Retirement funds are counted. And you don't really get to discount the amount. You can't just say that liquidating would result in a penalty, so that it shouldn't be counted. So in determining the value, you can subtract from the equity any early withdrawal penalties, but the retirement funds are counted, and just because they're in a retirement fund does not make them off limits for purposes of the asset eligibility test for all tax. Reverse mortgage payments. So payments received from a reverse mortgage are considered a conversion of a resource from equity in real property to cash, and those are counted. So if you have a reverse mortgage on your home and you're converting the equity in the home to cash, then that is counted. That cash is counted. It is not counted if you just have a line of credit that you have not drawn upon. So if you have a home equity, or if you have a reverse mortgage arrangement that is basically a line of credit, but you have not yet drawn on that, or to the extent you haven't drawn on it, then it's not counted. The conversion only occurs when the funds are actually advanced. But funds that you receive are counted as a resource where the equity in the home, if it's under the $552,000, and the equity would not be counted. Stocks are accountable. Trust funds, the entire corpus of a trust may be considered as accountable, again, depending on the type of the trust. And this is an area that here in Arizona, they'll look pretty carefully at the trust to determine if the applicant has any rights at all or any opportunity to receive any benefit from the trust. And if so, it's possible that the entire corpus would be treated as a resource, even though the applicant doesn't necessarily have a legal right to get at it. So in irrevocable trust, the applicant's entire ownership interest is counted as a resource. For an irrevocable trust, when a payment can be made from the trust principal to or for the benefit of the applicant, the maximum amount that is available is counted as a resource, whether it's actually distributed or not. The maximum amount that is available is included as a resource. And so trusts are an area where we have to be very, very careful in using trusts and making sure that they won't be counted, or be able to advise clients on whether or not they're likely to be counted. Testamentary trusts, for those created under the will of a person who's still alive, obviously the trust doesn't yet exist, and so that's not countable. So if they're if they're named as a testamentary trust under the will of somebody who's still alive, that's not yet a trust. Now, a testamentary trust of a person who has died, where the trust is in effect, then obviously that one is countable. Non-grantor trusts may be countable. If the applicant is a trustee, then the trust is countable to the extent the trustee can use the income and resources of the trust for his or her own benefit. So if it can be used for the applicant's own benefit and they're a trustee, the entire corpus would be counted, or any amount that they could use. If the applicant is a beneficiary, the trust is countable if the beneficiary can terminate the trust and access trust assets, or to the extent the beneficiary can access trust principal through an order to the trustee. So any legal right that the person may have, even though it's a non-grantor trust, any kind of withdrawal right, anything like that would be counted. Special needs trusts, if properly established, are not a countable resource. If they're limited and the person doesn't have any legal right to them, and it's limited in what those can be used for. So, but it's important that they're properly established, because again, they will receive very careful and strict scrutiny to make sure that they qualify. Uniform trust of minors accounts are not counted until a beneficiary reaches age 21. So if there's a younger beneficiary that is applying and there's a uniform transfer to minors account, that's not counted until the beneficiary reaches age 21, and then it would be. Vehicles, as mentioned previously, one vehicle can be excluded. Any additional vehicles are counted, and even that one vehicle, you have to be able to show that it's being used for the applicant or for members of the applicant's family. So if there's a community spouse, how do these asset rules apply where there's a community spouse who is not applying for benefits? So in determining the applicable community spouse resource deduction requires a community spouse resource assessment. So the allowable deduction in assets for a community spouse will range somewhere between $23,844 and $119,220. And for this calculation, we do know how that would be calculated. So you take the total countable resources of the two spouses and you divide them by 2. If that amount is between $23,844 and $119,220, then that amount is the applicable community spouse resource deduction that the community spouse can keep and wouldn't have to be spent down. If that amount is below $23,844, then $23,844 is the community spouse resource deduction. If it's above, so if the total amount divided by 2 is above the $119,222, then that's the cap. The community spouse, you can deduct $119,222 for the community spouse and still qualify. So the penalty divisor. So if there is a transfer and we're in the look back period, the penalty divisor depends on what county you're in here in Arizona. In Maricopa, Pima, and Pinal counties, the 3 most populous counties, the private pay amount or the penalty period divisor is $6,726.48. In all other counties in Arizona, that amount is $5,575.29. So that divisor or that private pay amount varies depending on the county. Okay, so now we're going to move to calculating the share of cost. We've got an applicant qualified, and so now Altex will determine whether or how much of the applicant's resources or the income available to them will be paid to the facility and how much they'll be able to keep. So the share of cost is calculated by subtracting the following from the applicant's income. So the applicant will get a personal needs allowance, perhaps a spousal allowance, if that applies, perhaps a family allowance, and we'll look at all of these, a home maintenance needs allowance, a community spouse monthly income allowance, health insurance premiums, non-covered medical expenses, and a special deduction for residents of someone staying in an Arizona veterans home. So those are deductions that the applicant can keep personally, and the balance goes to the facility. So the personal needs allowance for an applicant who resides in a long-term care facility is $109.95. So that's the personal needs allowance they get to keep. Now, if they're not in a long-term care facility, then applicants get basically to keep the full amount. There's not a share of cost. It's not referred to as a share of cost. It's referred to as a room and board, and so they'll be able to keep that. The spousal allowance, now this is only applicable if eligibility was determined using non-community spouse rules, and there is a dependent spouse and no dependent children. So if we use the community spouse rules, then we've already calculated that deduction. But if we didn't, there's an additional community spouse allowance of $733 less the spouse's counted income. So if the community spouse has no income and we didn't use those rules to shelter any other income from the spouse, then the applicant spouse gets to deduct $733 less whatever income the community spouse has. The family allowance, again, this is only eligible if eligibility was determined using non-community spouse rules and the applicant has the dependent children at home. And then this deduction is based on the number of dependents that would be at home. And these are standardized deductions under the Access Eligibility Manual. One dependent at home, you get a deduction of $567. If there are 2, you get $765. And there's a chart in the Eligibility Manual. If you had 13 dependents at home, then you'd get a deduction of $2,945. So there is a family allowance, but again, only if you use the non-community spouse rules and there are dependent children at home. The home maintenance allowance is applicable where eligibility, again, was determined using non-community spouse rules, and the applicant is likely to return to his or her own home within 6 months of the date that the applicant enters the institution. And if that's the case, then there's a monthly allowance of $210 that the applicant could keep for home maintenance costs. Again, if they did not use the non-community spouse rules and they're likely to return home within 6 months. Okay, so then the community spouse monthly income allowance. So as a general rule, the community spouse monthly income allowance will be the higher of, that should be instead of if, the amount of monthly support ordered by a court or the calculated community spouse monthly income allowance, which is not the same as the resource allowance that we talked about earlier. So this is an income allowance that the surviving spouse would be able to that you could use to provide for a community spouse. So you take the spouse's verified shelter costs, if any, and you add to that a utility allowance of $271. You subtract 30% of the monthly spousal needs standard, and that 30% is $598. The standard is $1,992. So you subtract that amount, and then you add that value to the standard, which is $1,992, and then you compare this to the maximum monthly spousal maintenance needs standard in the rules, and that's $2,981. So you take the lower of the 2,981 or this calculation where you take the verified shelter costs that are determined, you add this, you subtract this, you add this. If that is less than the 2891, then you use that lower number. If it's greater than that, then you use the 2891. And then you subtract that amount from the counted monthly income of the community spouse. So if the community spouse has counted monthly income less than this 2891 or less than this calculation, then there's an additional spouse monthly income allowance that can be protected for the applicant's spouse. Health insurance premiums are deducted in determining the share of cost, as are non-covered medical expenses. So medical expenses that are necessary but are not covered by the program can be deducted for determining share of costs. So that's deductibles, co-insurance, co-pays, dental services for persons over 21, hearing aids, eye care, chiropractic, and other necessary services. There's a special deduction for residents of the Arizona Veterans Home. An applicant who resides there receives an additional $90 share of cost deduction when they're a veteran or a surviving spouse of a veteran and residing in that home. So let's turn to some common planning strategies that work here in Arizona. And so Miller Trust, as we talked about, this is used when a applicant's income exceeds the $2,199. So say an applicant's receiving retirement benefits of $2,500, and that would disqualify them from being able to qualify. We can use a Miller Trust, put the balance into that Miller Trust, and these are pretty straightforward in preparing. You've got to comply with the federal rule, but you create the Miller Trust. The excess income is not counted. It is calculated in determining the share of cost, and then the Miller Trust is available for providing. So so the Miller cost may end up going to the facility, but at least you still qualify. So Miller trusts are very helpful and available here. Home renovations is a strategy. So the Altex policy manual doesn't expressly address funds used in renovating a home, but as we indicated, the home equity of a home where there's a possibility of a person returning is exempt and not accountable assets. So the purchase of household goods and personal effects also do not incur a penalty period. So renovating a home, improving a home, adding to the value of the home, as long as you're under that equity amount, can be a valuable and helpful planning strategy. Purchase a prepaid burial or a burial fund. So the applicant and the spouse can both have prepaid irrevocable burial fund or prepaid burial up to $1,500. Again, the key here is that it's irrevocable. If it can be refunded, if you can get it back, then it's a countable resource. But an irrevocable one is not counted. The purchase of a burial plot. For the applicant or an immediate family member, the burial plot is an excluded resource. So you can purchase that. Annuities, as a general rule, are counted as a resource, but they can work really well for married couples in situations where the applicant's spouse's income is less than the $21.99, so that the well spouse's income can be unlimited. So if the applicant's spouse is under $21.99, then we don't have to count the applicant's spouse's income in determining eligibility. Now, in determining some of the deductions, as we've talked about, we do look at the well spouse's income, but we may not need those deductions, and so the well spouse can have income potentially from an annuity that could be substantial. So the purchase of an annuity is a compensated transfer if it meets certain criteria. Those criteria are set out in the policy manual reference there. When using a compliant annuity, you need to be sure that the Medicaid applicant spouse has less than $2,000 in countable assets in his or her name at the time of application, so that once the application is approved, the Altex customer is in the post-initial rules, and the well spouse is no longer limited to the community spouse resource allowance limit. So we need to make sure that the applicant has assets under the $2,000 at the time of application. So that planning is important. The timing is important in obtaining those annuities. Buying income-producing real property. While there are some planning opportunities here, it's not generally recommended. There are lots of restrictions. Those are set out in the eligibility manual. You can take a look if it's absolutely essential or something that the client really wants. But it's a very complex area, and like I say, not generally recommended. The property may not be in use for reasons beyond the customer's control, and the property use must meet one of these three uses. Business property used in a trade for employment, non-business property that produces at least a 6% rate of return, and property that produces goods or services for the customer's needs. And again, there may be an exception for the use of a home in generating income, as indicated in the policy manual there. Now, promissory notes don't work well in Arizona for Altex planning because notes that are negotiable are considered available resources for eligibility, and notes that are non-negotiable are considered uncompensated transfers or potential gifts. So notes are not favorably looked upon and don't work well in Arizona. Gifting plus a partial return is a strategy that also no longer is recommended in Arizona. Return of a full gift is required in order to reduce the penalty period, so you don't use the partial return, and gifted funds are considered to be held in a constructive trust and are therefore an available resource to the applicant. So this is a strategy that doesn't work in Arizona. Personal service contracts also are not real useful because of significant all-tax restrictions here. So they are valid and they can be used. They're a valid form of compensation, but the restrictions include that payment cannot be made for services provided in the past, and lump sum payments are not allowed for future services. So personal service contract must provide for payment at least twice a month. It can be more often, but it has to be at least twice a month. And so personal service contracts are not a way to really, you can't pay for past services, and you can't pay in advance for future services. And so there's some real limitations there. But under those restrictions, they are recognized and they can be used. Life estates are, again, not recommended in Arizona because the value of the life estate is considered as a resource. The value of a life estate is excluded only if the property would otherwise qualify for a home exemption and the applicant lived in the home for at least a year. But you don't need the life estate for it to otherwise qualify as the home exemption. But if it does, if you have a life estate that qualifies as a home exemption and the applicant lived there for a year, then that life estate can be excluded. But as far as just a planning strategy, it's not real helpful. Transferring the home to a specific person or to a trust, to a specific person can work well. An applicant can transfer the home or property to any of the following without affecting eligibility. So a transfer to a spouse of the home works, to an applicant's child when the child is under 21, a child of any age who's lived in the home for at least 2 years immediately before the applicant enters the institution, if the child provided care to the applicant. So if you have a child providing in-home care, and you can transfer the home to that child. An applicant's sibling who has an equity interest in the home, if the sibling lived in the home for at least a year before the applicant enters the institution. So a sibling co-owns the home and lives in the home and had lived there for at least a year, you can transfer to that sibling without affecting eligibility. And a child, a transfer of a home to a child with a qualifying disability. So if we've got a child with a disability, then you can transfer there. Now, transfers to trusts can be used, got to be very careful, and one of the big benefits of Elder Counsel is the resources they provide in order to be able to be careful where these can work. But you must be cautious. Assets held in irrevocable trust may be counted as available resources, even if they would otherwise qualify as excluded assets when held by the individual applicant. So you've got to be very careful with trusts, again, but they're going to get increased scrutiny, and so you can take something that would otherwise not be counted, have it in a trust, and have it counted. So you have to be very, very careful. The Medicaid Asset Protection Trusts can work and do work, but again, you have to be very careful with them because there are no partial cures. If any of the income or principal from the trust can be used for the all-tax beneficiary or spouse, the entire trust is considered an available resource. So the trust must expressly state that no income or principal can be used directly or indirectly in a Medicaid protection trust. So if they've created a trust, you've just got to be very, very careful about this. Every trust is reviewed individually by the all-tax legal department, and there is very strict scrutiny here. So they can work, but you have to be careful. Transfers to trusts, trust for disabled individuals under 65. The transfer policy does not apply to income or resources transferred when the applicant or customer is under 65 years of age. Any income or resources added to the trust after the customer applicant turns 65 would be reviewed as a transfer. And pooled trust, same thing. If can be used when the applicant is under 65, over 65, not available. So that's the end of the materials that I have here today. It's been a pleasure to present these, and it's been a pleasure working with Elder Counsel and putting them together and in working in this area. This is a fun area to practice, a very rewarding area to be able to help clients and families navigate this complicated process, and Elder Counsel is a great resource in helping us do that. So thank you very much.